Hey Mo, hey PT, ready to do it? Indeed, let's do it. Let's do it.
Welcome to the epic, the sardonic, the titillating Best Fit Square!
Hey everybody, I'm Manuel Ortega, and this is Best Fit Square Show. Hey everybody, that's PT. Hey PT, hey Mo, have we got a great show for you today? Indeed, Mo. Hey, when it comes to landmark Supreme Court decisions on race, which come to mind? Of course, Brown v. Board of Education, 1954, classic. This ended segregation in schools. Then there was Loving v. Virginia in 1967. Another classic. This prohibited restrictions on interracial marriages. Hey, PT, didn't laws like this violate the Equal Protection Clause of the 14th Amendment of the United States Constitution? Well, not exactly. States have the right to enact their own legal framework. States have a right to fabricate racist apartheid law? They'd argue otherwise. Racist apartheid practices date back to pre-Constitution colonial days. It wasn't until after the Civil War that certain state laws clashed with federal law. Then, in 1896, with its Plessy v. Ferguson decision, the Supreme Court fabricated the legal framework from which Jim Crow emerged. Isn't that the decision upholding the constitutionality of state laws requiring racial segregation under the doctrine of separate but equal? That's right, Mo. With that decision, the Supreme Court of the United States, in effect, sanctioned state-sponsored terrorism. Then 40 years ago, the Supreme Court decided another pivotal case on race and equality whose fallout profoundly shaped American race relations to date. What case was that? Washington v. Davis. Never heard of it. You're not alone. Go on. In 1976, Washington v. Davis was up for review by the Supreme Court. The case involved constitutionality of Test 21. A test developed by the federal government and used by the District of Columbia Police Force to assess people looking to become police officers. What was the problem? The issue was whether a race-neutral test that led to vastly different racial outcomes violated the Equal Protection Clause of the 14th Amendment. Race-neutral smacks of the long-held U.S. tradition, from grandfather clauses to literacy tests, of seemingly race-neutral measures functioning in a discriminatory manner. You got it, Mo. The United States Court of Appeals for the District of Columbia Circuit found that Test 21's grossly disproportionate negative impact on minority applicants violated the Equal Protection Clause. Right side of history, but when the case reached the Supreme Court, the justices disagreed. Being this was 1976, wasn't this going against the grain of the era's racial progress? Indeed. Regardless of the era's tilt toward racial equality, what the justices concocted was that unequal outcomes was not enough evidence to prove discrimination. One also had to show a discriminatory purpose. Discriminatory purpose? What the heck is that? Discriminatory purpose means that one has to demonstrate the law's intent is to discriminate. How the heck does one demonstrate intent? Exactly, Mo. This opened the door to what is now known as the intent doctrine, which emerged in later cases as a simplistic search for a smoking gun. The smoking gun being individual bad actors intentionally doing bad things with nothing but racial animus on their minds. Good luck with that. It marked the beginning of the Supreme Court's turn away from acknowledging how the weight and inertia of America's openly structural racism have embedded themselves into practices like Test 21 that have no easily discernible discriminatory purpose. So how did this play out in future cases? Excellent question, Mo. Let's take a look at the 1987 case McCleskey v. Kemp. All right, Warren McCleskey, an American of African descent, was convicted in a Georgia trial court of armed robbery and murder. The jury recommended the death penalty on the murder charge. The judge agreed, and the Georgia Supreme Court affirmed. Case closed. Not quite. Mr. McCleskey's petition included a claim that Georgia's capital sentencing process was administered in a racially discriminatory manner in violation of the 8th and 14th Amendments. That was ballsy. Did he have any supporting evidence? Yes, he did. Mr. McCleskey provided a statistical study showing that black defendants charged with killing whites were 4.3 times more likely to be sentenced to death than white defendants who killed blacks. So here we have a state, Georgia, with an indisputable long history of racial discrimination, coupled with a statistical study plainly demonstrating racial bias in sentencing, put squarely before the Supreme Court. That's correct. But the court found Mr. McCluskey failed to demonstrate, 1, that the decision makers in his case acted with discriminatory purpose, and 2, that the Georgia legislature enacted or maintained the death penalty statute because of an anticipated racially discriminatory effect. Damn, PT. This approach reduces the Equal Protection Clause to a judicial examination of individual mindsets, as opposed to being attentive to the structural nature of racism. By not taking structural discrimination seriously, the Supreme Court made a mockery of history, justice, and common sense. So what happened to McCluskey? He was executed in 1991. Just saying!